The rule book constitution says 7 days after the CTC copy of a judgment must be delivered to those concerned. We're talking about the Supreme Courts here, not even the lower courts, the apex courts. Go to Imo State, there is that issue there since November 11 election. They have neither released it, or maybe they released it just yesterday or thereabout. Kogi State, the same issue. The court subpoena had to order 48 hours for INEC to release this. Why do you think the INEC and the judiciary seem to be towing a line that creates more doubts, or that discourages the Nigerian people more when it comes to elections and electioneering processes?
Well, it's nation building. I repeat, it's work in progress. The general elections of 2023 and the judicial processes thereafter have raised a lot of dust, as to the ability of the judiciary to cope with certain processes. While we are looking at Odinkalu's position, he has made some very serious remarks, almost tending towards indicting the judiciary. But strictly speaking, as a citizen, we wouldn't know what the issues are with the judiciary. Well, if where the rules of courts have established that it should be 7 days and a maximum of 14 days for the CTC of these judgments to be made available, and there's a breach, I think as citizens, if the likes of Professor Odinkalu feels very aggrieved, there are also some administrative reliefs. I wouldn't want to bring INEC into this matter because the processes have been virtually consummated, going through the tribunals, the Presidential Election Petitions Court, and then also going through the Supreme Courts. I think it's something that has been concluded. So INEC may have given evidence in these courts, but the ball is currently squarely in the courts of the Supreme Court to make sure that the CTCs are made available. Like I mentioned, Odinkalu, they have every opportunity to seek administrative redress. There are some reliefs, some of them judicial reliefs. For instance, when things like this happen, you can bring an order of mandamus and compel whoever is responsible or ought to have released these judgments to do so. Compelling public officers to do certain duties which they may have by commission or omission neglected to do. So there are such judicial reliefs. That is on the one hand. Now the other issue that he had raised is that if now that courts are now the deciders of the votes of the citizens, and generally that is an area that we have to look at. I believe that it was in that context that the Chief Justice of Nigeria came out very strongly, I think 2 days back, to say that the courts, the judges should not be intimidated by emotions, but should purely be guided by the law and the evidences and facts that are adduced by the parties. And I believe in what the Chief Justice said, but I also think that with what we have seen so far, that we expect that the judiciary should also do better. When people come to voice such an opinion, the likes of Odinkalu, they are not saying it for fun. You saw what the dispensing of the judgment in Kano, where you have two different judgments. The one that was given verbally is different from the content of what was in the CTC, to the point that cost was actually awarded. So I think the judiciary needs to do better.